All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's special history series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Quite often, and many of our most famous decisions are ones that the court took that were quite unpopular.
Let's go through a few cases that illustrate very dramatically and visually what it means to live in a society of different people who help stick together because they believe in a rule of law.
Good evening and welcome to Landmark Cases. Tonight we are going to be looking at Yick v. Hopkins. It's an 1886 case in which the Supreme Court ruled that the 14th Amendment's equal protection guarantees apply not just to citizens, but non-citizens. For the next 90 minutes, we'll learn more about what led to this case and what the effect of its decision has been on American society. Let me introduce our two guests who will be at the table to help us understand all this. May Nye is a historian and professor of Asian American Studies at Columbia University. She's the author of two books, Impossible Subjects and The Lucky Ones, and she will be helping us understand all of the issues around Chinese immigration and the Chinese Exclusion Act in the late 19th century. Josh Blackman is with us, associate law professor at South Texas College of Law. He's the founder and president of the Harlan Institute, which develops constitutional law curriculum for high school students. Josh, welcome to C-SPAN.
Thank you.
So as we start here, I'm going to ask you to give us just the most basic facts about this case.
Yick was decided in 1886, so roughly 18 years after the 14th Amendment was ratified. In this case, California enacted a law that required people with laundromats in wooden buildings to apply for a permit. Now, there's no criteria of when a permit should be granted. As it turned out, almost all the people who applied that were Chinese were denied permits, but all the people who were white and applied for permits got them. This was a criminal offense, and Mr. Lee Yick was actually imprisoned because of his failure to pay a fine. This case was appealed to the U.S. Supreme Court. And the Supreme Court held that this was unconstitutional. They found that the standards by which these permits were denied were completely arbitrary, and that it was implemented with, quote, an evil eye and an unequal hand, and as a result, it violated the 14th Amendment. And this was the first major case after the 14th Amendment's ratification that applied this provision to non-citizens and found that a state law violated those laws.
And it has implications for us today. Later on in the program, you're going to tell us about some very big recent cases that use Yick as case law. What's one, for instance?
So one of the most famous recent decisions was the Guantanamo cases, Boumediene, which stands for the proposition that even aliens, non-citizens held at Guantanamo Bay, do have some protections under our Constitution.
We're going to be learning a lot about the 14th Amendment during this series. It's the 150th anniversary of the amendment, and a number of the cases that we've picked for this season have the 14th Amendment as the case law, the constitutional provision that's being examined. Let's look at just a little bit of it concerning the Yick case. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. But later on it says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person, and that's the critical phrase here, within its jurisdiction, the equal protection of the laws. May Nye, why is this a landmark case?
Well, you know, a lot of people just assume that the 14th Amendment applies to citizens, but by saying it applies to persons, it means that every person living territorially in the United States is protected by the Constitution, and that's huge because that really is an equal rights provision.
This program, if you're a regular watcher of this series or you saw our first one, you know the best part about it is your interaction. In about 20 minutes, we'll be taking your phone calls around the country. We also have a Twitter feed with the handle Landmark Cases or hashtag Landmark Cases. And we've already got a robust conversation going on C-SPAN's Facebook page. And you are welcome to join any of those as a way of connecting with our guests and being part of the conversation. 202-748-8900 if you live in the Eastern or Central time zones, 202-748-8901 for the Mountain or Pacific time zones. Well, May and I, we're going to learn from you about Chinese immigration in the late 19th century. What was the impetus for so many Chinese coming to the west coast of the U.S.?
Large numbers of Chinese begin coming to California in the 1850s, and they come for the California Gold Rush. They come for the same reason that everybody else is showing up in California. People from the eastern United States, from the southern United States, people from Mexico, from Chile, from Europe, from the British Isles. Hundreds of thousands of people are showing up in California, and it includes the Chinese. So they're not alone in coming, and they're coming really for the same reasons that everybody else is. They're trying to see if they can get their lucky strike.
And what kinds of numbers are we talking about over the last couple of decades of the 19th century?
Well, in the 1850s, there's probably upwards of 20,000 Chinese who come. It's not a huge number compared to the overall population, but Chinese comprise about 20% of the mining population. So, and by the mid-1850s, they're the largest non-white group in the mining districts.
And what other kinds of work did they do, or would they find?
Well, you know, Chinese were received, I think, in the gold fields with some ambivalence. You know, there wasn't racial conflict everywhere. People worked side by side and got along, but there was also conflict that is born out of competition. And the easiest way to compete with somebody else is to hurl some kind of racial slur at them, that they don't belong there, they're not Americans, etc. So many Chinese were, their claims were jumped, they were attacked. Local districts passed laws saying that Chinese could not have first ownership of a claim in those districts. So there were attempts to drive the Chinese off of the gold fields. But they let them back in, kind of, you could say, through the side door to do jobs in the small mining towns that the miners themselves didn't want to do. Typically, it was cooking food and washing clothes. Those were considered women's jobs, domestic work, and there were very few women in the gold fields in the first decades. It was mostly men. So that's how Chinese came to work in those occupations.
And when the U.S. embarked on the building of the Transcontinental Railroad, how did Chinese laborers fit into that?
Well, when the railroad starts to be built in the late 1860s, a lot of the surface mines are beginning to be depleted, so both whites and Chinese are out of work. And Chinese are hired to work on the railroad in part because the railroad companies think they're actually better workers than former white miners who don't really take to labor discipline. They drink, they walk off the job and things like this. So the Chinese become a preferred labor force for the railroad, and they include, as I said, former miners, but they also recruit workers in China to come over and work on the railroad.
So when we get to the 1880s, which is when this case begins to percolate, what's the size of the Chinese population, especially in Northern California, San Francisco area?
By 1880, there's probably about 100,000 Chinese in the state of California. And they're about 10% of the state population, but 20 to 25% of the working population, because the Chinese tend to be working-age men, and most of them don't bring families to this country.
And what is life like for them?
Well, it's hard. You know, they work hard. There's a lot of discrimination. In San Francisco Chinatown, they work in not just restaurants and laundries, but they work in woolen mills. They have jobs for some large companies. They do track work, they do infrastructural work, but they come under increased attack by white working men, or whites who fancy themselves to be working men. Some of them aren't really workers. They're acting as though they're workers, to say that the Chinese are taking jobs away from whites. So there's a lot of violence against Chinese. There are mobs that roam the streets, burn down Chinese homes, attack people on the streets. Mobs of kids who will just throw stones at random people walking by. It's a pretty ugly scene.
For the most part, did the Chinese workers who come assimilate at all, or did they cluster together? Do you know about their English language skills and whether or not they really work to become part of society?
Well, yes and no. I would say some of them do try to learn English. There are some schools that are set up in San Francisco Chinatown to teach English, and the students are mostly young adult men because they want to get along. They want to be able to do business. They want to be able to talk to their neighbors. So there are Chinese who learn English, and those classes are mostly given by missionaries who see teaching the Bible as a way to assimilate Chinese. I would say that they don't all become Christians, but they do try to learn English. But the difference with Chinese immigration is that Chinese custom is for men to go abroad and for the wife to stay at home. So they don't, as a rule, bring their families over here. And then once they get here, life is so hard and it's so violent that who would want to bring your wife over to a situation like that?
What about the popular media of the day? How do they deal with the Chinese immigrants in California?
Well, I think it varies. You know, some of it's just straight reporting. Some of it is some ugly cartoons that are printed around the country, not just in California, depicting the Chinese as a problem. There emerges something that is known as the Chinese question, which is understood to be a race question. What do we do with this unassimilable race? That was the accusation that was made towards Chinese. So there was a lot of political cartoons published in the national press about the so-called Chinese question.
Our case is about a local law, and we're going to learn a little bit more about how the legal infrastructure was really used to help the majority population control or contain the Chinese immigrants. Next up is former California Appeals Court Judge Harry Lowe, who talks about some of the legal challenges faced by the Chinese immigrants to the United States.
They were very, very much the subject of discriminatory activities. Kind of reminded of the case of People against Hall, which is 1854, a very early California Supreme Court case in which several Chinese witnesses saw a murder. They testified honestly what they saw. He was convicted. His clever defense attorney appealed the case to the California Supreme Court, and he argued there's a law in California that's Indians and blacks do not testify against a white man, and that there's only three classes of people in the world: whites, blacks, and Mongolian. Indians included Chinese, and Chinese were Mongolian, Indians were Mongolians, and the California Supreme Court bought that argument. And if we let them testify against a white man, why, the next thing you know, they'd be sitting on a jury box, they'd run for the legislature, they'd vote, they might even become judges. What a terrible thing that would be. And a very racist type of decision. And so it set the tone of California history for about the first 100 years.
May-Nai, what can you add to Judge Lowe's story?
Well, that is a very important case, People v. Hall, and he's absolutely right what he said. But what I want to point out is that they were applying a law that was originally written to exclude blacks and Indians from testifying against white people. So I think what we have to understand here is that in the 1850s, California was not friendly to people of color, period. So just as in this case, Chinese were then added to the anti-miscegenation statutes, which already were written to forbid blacks and Indians from marrying white people. Chinese were excluded from schools, but they were not the first to be excluded from schools. The first to be excluded from schools were blacks and mulattoes, quote unquote, and Indians. So California has a pretty bad record in terms of how it treated people of color, even though it enters the Union as a free state.
Josh Blackman, most high school students have heard of Chinese exclusion laws. What are they?
So these were a series of laws enacted in the 1880s that placed significant limitations and eventually prohibitions on the immigration of people from China to the United States. And these laws also put limits on Chinese people inside the United States, such that if they left, there were certain difficulties to re-enter. as well as long as they stayed here, they had to obtain these certifications, these papers, basically, that be carried upon them at all times to make sure that they were lawfully in this country. So it was an entire scheme that began in the 1880s and really lasted until the 1960s that limited immigration from China and put limits on how Chinese people could exist within the United States.
So our case, again, is the San Francisco Board of Supervisors and their regulation about laundries. Would you explain how the Chinese became so involved in the laundry business in San Francisco?
Well, as I said, they started in the gold mining towns doing wash for people, and it carried over into the cities. There were many Chinese laundries. There were whites that owned laundries too. Chinese did not run all of them. But they were not all in Chinatown. They were all over the city. They tended to set up a laundry in a neighborhood where it would be convenient for people to use it. So Yick Wo's laundry, for example, Yick Wo Laundry was not in Chinatown. It was at 3rd and Harrison, which is south of Market Street.
In the years of this case, there were 320 laundries operating in the city of San Francisco. And so the regulation or the law that the San Francisco board in place did what to the laundries? What did it say that was responsible?
Well, it said, the law said that all new laundries had to be constructed out of brick or stone. But if existing laundries, which were made out of wood, which they all were, practically all were, could only continue to operate if they got a permit from the city. And this is what led to this charade, really, where they approved all the permit applications that white people made, save for one, and they denied all the Chinese. So, in a way, this is not really about fire safety. It was one of quite a number of municipal ordinances that were passed to harass the Chinese. If we make life so miserable for them, if we make it impossible for them to earn a living, maybe they will leave.
So enter Lee Yick, who is one of the proprietors of a laundry in San Francisco. In fact, he'd been running it for 20 years. What more can you tell us about him?
So, in fact, you said it correctly. His name was not Yick Wo, it was Lee Yick. Yick Wo was the name of the laundromat. In fact, when the original case was filed, no one bothered fixing the fact they didn't even get the guy's name right, which probably showed how much they cared for the people living in that jurisdiction. He was a laundromat owner, and he refused to pay a fine of $10 because he was denied this permit. He was then sentenced to a term in prison because he wouldn't pay this fine. He filed what's called a writ of habeas corpus to try to get himself freed. The California Supreme Court rejected his appeal, and then it went to the U.S. Supreme Court, where the U.S. Supreme Court reversed and said you have to let Mr. Lee Yick go free because this California law is completely arbitrary and it deprives him of his rights under the 14th Amendment.
He was representing a number of Chinese laundry people. He really took the case on, but in fact there were a group of people protesting this. When I thought about this at the time, these are people who are not in their home country and not in a country where they have the same rule of law, and yet they chose a legal path to protest. I'd like to have both of you comment about really what that means about their confidence in the American system.
The Chinese were very savvy, they were organized, and they knew the laws of the country they were living in. It may not have been the laws from their own country, but they knew they were living in a foreign country, and they wanted to play by the rules, so they knew the laws. Mr. Lee, for 22 years when he ran that laundry, he was duly licensed. He had his laundry inspected every year according to the law. They know the rules. They learn the rules, and they want to play by the rules. So now this case was not a random case. It was a test case. The Chinese were organized, just like the NAACP brought test cases like Brown and other cases to test the constitutionality of laws that they believe are discriminatory. The Chinese also brought test cases, and they were well organized. They were backed by an organization called the Chinese Six Companies, which was a coalition of the merchant leaders of the community that represented Chinese according to their home district, right? These are like mutual aid associations that all immigrants have based on their hometowns. Well, the Chinese the leaders had money. They also were supported by the Chinese consul, which also supported these cases. So they challenged these cases in the courts. And they also did that because they did not have the vote. The exclusion laws said that Chinese could not naturalize as citizens. They had no political muscle whatsoever because they could not elect people to Congress. So they used the courts as their strategy.
The case bears also the name Hopkins. Who was Hopkins?
Hopkins was the sheriff at issue who's responsible for enforcing the fire law. Not too much is known about him. I think May raises a very fair point. There were several cases brought by these Chinese immigrants challenging these various policies, and they basically lost them all. Yick was one of the few cases that actually ruled in favor of the Chinese immigrant. So in this sense, it was a very smart test case, because it wasn't testing the power of Congress to deny entry. It wasn't testing the power of Congress to deport people. It was testing the power of the state to deprive someone of a property interest, a liberty interest. What was at issue? These were small business owners who had a lawful business, wasn't bothering anyone, they were safe, and this arbitrary regime was put in their place. So this was actually an argument that would appeal to the fairly conservative Supreme Court, that there's a liberty interest in having a right to pursue an honest living. And that is where they actually prevailed. The other cases, they all lost.
You're watching our discussion of a landmark case called Yick from 1886, which still has implications today because it said that the Constitution's due process guarantees under the 14th Amendment apply to citizens and non-citizens equally. We're going to be going to your calls, and then in the next segment, we're going to learn about how this case went to the Supreme Court in 1886, what the court looked like then, and how it was decided. But as we get into that, let's listen to a current member of the Supreme Court, Anthony Kennedy, as he talks about the importance of the Yick case.
Yes, he said this law, assuming that it was passed for a legitimate purpose, and I have a big question about that, was applied with an evil eye and an unequal hand, a metaphor that bothers me a little bit. It's kind of a mixed metaphor. It should have been with an evil eye and a malicious hand, I think, poetically, to make it the same. But he said it was discriminatory in its application, and he had a lot of evidence for that. The number of the whites that were given permits, the number of Chinese that were denied, a very strong case. It says that even though the law is valid or neutral, fair on its face, if in application it's being applied in order to hurt a particular race, it's void. That's a tremendously powerful principle, and that's why the Yick case is cited today.
Justice Anthony Kennedy on the importance of Yick to our society today. Let's take some of your calls. We're going to begin with Jim in Omaha, Nebraska. You're on. Welcome to Landmark Cases.
Yeah, thanks for taking my call. I noticed that when you first started your show, you talked about the second sentence of the 14th Amendment, and you said non-citizens, and basically because of what it says as far as persons twice, it said, nor shall any state deprive any person of life, liberty, or property. And I know the other part is you said any person within its jurisdiction equal to protection. But the first sentence of the 14th Amendment clearly states all persons, so you can use that persons, born or naturalized in the United States shall be and subject to the jurisdiction thereof, that a lot of people don't really understand what that is, are citizens of the United States and of the state wherein they reside. So my question to your guests there, and see if they can talk about this, is we use the same phrase, person, to describe what a citizen of the United States is. So I'm thinking the persons later on are considered citizens too. These amendments in our Constitution and the Constitution as a whole are for citizens of the United States and not for non-citizens or individuals that come across our border.
Okay,
so
thank you, Jim. Well, why don't we pick it up from there? Thanks for your call.
So the Constitution, as I knock my microphone over to pale my pocket Constitution, provides that all persons born or naturalized become citizens. But it also says that all persons, whether citizen or not, are given certain rights of life, liberty, and property, and equal protection of the law. Now, the court has held that non-citizens do get lesser rights in certain respects. For example, if you're a resident alien, you cannot contribute to a political campaign. If you're a resident alien, you cannot bear arms. So there are certain rights which do not apply to citizens. But for the most part, citizens and non-citizens within the United States, according to the Supreme Court, are given equal protections of the law.
You talked about this before, but we have a tweet from Doc Darnell where some Chinese immigrants educated in the law in order to file on the launderer's behalf.
They all hired white lawyers to argue their cases.
Interesting. Up next is a call from James in Caliente, California. Hi, James. You're on in our discussion of Yick v. Hopkins. Welcome.
Thank you very much. Thanks for taking the call, and thank C-SPAN again for putting on these shows. They're quite terrific. My question is rather specific, not related so much to the law, but the guest spoke about Chinese coming over here to work in the gold fields. I live in an area that is a played out. Basically, it's a ghost town in the Sierras. And how many Chinese, as percentage, if you know this, were able to make a successful living in gold mining? Very few people did, I think. I think most people who came went into something else. Again, Chinese going into laundries and restaurants, the white people going into all sorts of other things. Very few people made money in gold. Did any, or did a decent percentage of Chinese make money in the gold fields?
I think they did about as well, or not as well as anybody else.
Which means not so well, except for a few lucky people. Well, on to the Supreme Court. At the time that the case came to the court, Grover Cleveland was president of the United States, but the Supreme Court itself looked very much like it did in our last case, the civil rights cases. The Chief Justice was Morrison Waite, who had been nominated by Ulysses S. Grant. And the Associate Justices of the Supreme Court were all Republicans except for one. They were Samuel Freeman Miller, a Lincoln appointee, Stephen Johnson Field, also Lincoln, and he served the second longest tenure of any justice on the Supreme Court, 1863 to 1897. William Burnham Woods, a Grant appointee, Joseph Bradley, a Grant appointee, Horace Gray, an Arthur appointee, Stanley Matthews, who wrote the decision in this case, a Garfield appointee, John Marshall Harlan, a Hayes appointee, and the Johnson Democrat appointee was Samuel Blatchford. What should we know about this court in general?
So, as a whole, in the civil rights cases, the court was fairly consistent that Congress lacked the power to provide additional protections for the freedmen, freed African Americans. In that case was one dissenter, John Marshall Harlan, who said that laws discriminating and private businesses discriminating against the freedmen were badges and incidents of slavery. And he thought that the 13th and the 14th Amendments prohibited this form of racial segregation against African Americans. Notice Justice Harlan did not dissent he did not write anything separately in Yick Wo. A few years later, in Plessy v. Ferguson, Justice Harlan again dissented, arguing that exclusionary laws, that separate but equal, is unconstitutional. But he had a very famous part of his opinion where he said, while we're able to give protections for the freedmen, there is a race very different than ours, and that is Chinese people. So Harlan, who was very much progressive with respect to equality for African Americans, didn't seem to feel quite the same way about Chinese people. So on this court, there wasn't much of a friend for racial equality for people from China, yet this decision was a unanimous judgment in favor of Mr. Lee Yick.
For some of you who are just learning about these cases, we have a companion book available. It is $8.95, I think, just about our cost, and we'll get it out to you real quickly if you're interested. You can go to C-SPAN's website, Landmark Cases. Tony Morrow, a veteran Supreme Court reporter, has written all of the synopsis of the case and tells you more about the time in which it was argued and also its current legacy. This case was argued on May 10th, 1886. At that point, the Supreme Court was meeting in the part of the Capitol called the now called the Old Senate Chamber, and I think we've got a picture of that room, which is a very ornate room, still available and still in use in the United States Capitol. What's unusual about this is that there was no oral argument. They depended all on briefs. Why is that?
Well, back then, the court heard a lot more cases than it does today. And it simply wasn't feasible to have every single case argued. In fact, if these parties from California, that was quite an arduous journey. And to be frank, I'm sure Mr. Lee Yick wanted to get out as quickly as possible and get this sentence off of his head. So I don't think they minded having this case resolved on the papers. The court back then wasn't as big as it is today. I think it's very common to apply a 20th century lens to the 19th century Supreme Court. It wasn't until the Warren Court in the 60s that people started caring what the Supreme Court said. These cases were of relevance, but for the most part, people went on their businesses and didn't pay much heed to the Supreme Court like they do today. There were no C-SPAN specials about the Supreme Court back in the 1880s.
Nor no C-SPAN, of course.
Was there.
So the arguments made on behalf of the laundry owners focused on what? What were the points they made?
Well, the laundry owners tried to say that these laws are not being enforced in any sort of a consistent manner. The key point is arbitrariness. Generally, if you want to have a permit, you say you need to have proper ventilation for this laundromat. You need to have it has to be clean. It has to have good equipment, right? The law at issue in this case in San Francisco had no standards. It just said you apply for a permit, period. And they said that there's no standard against which these permits should be granted, and that arbitrary enforcement itself was unconstitutional.
We'll take some more calls, and then we'll hear about the arguments made by the city's lawyers. Next up is Robert in Middletown, New York. Hi, Robert. Welcome.
Hi, good evening. I'd like to thank the guests for taking the time and sharing their insight into this important case. It is clear that in Yick stood in sharp contrast to the previous interpretations of the 14th Amendment. SCOTUS held here that the 14th Amendment applied to non-citizens. However, it is not until much later, in cases like Griswold v. Connecticut, that Yick came to stand for fair and equal government. However, the holding in Yick was no help in preventing discriminatory rulings in cases like Plessy v. Ferguson. Why do the panel members believe this is so?
Thank you.
Well, I think Yick has, it has actually more than one meaning. One of the reasons why the court passed it was to extend the rights of the 14th Amendment to economic rights, the right to pursue an occupation or a trade or a living. And that is also why we have, I think, part of the wording for person, right? Because a legal person need not be a human being. A legal person could be a corporation. So there was a lot of interest in this case as a property case, as my colleague here mentioned before, the right to have a business. But I think it also has come to stand as a case about discrimination, about arbitrary application of the law. And I think it's very telling that in the decision, the justices said that even if it's not explicit in the law, if its application is manifestly discriminatory, it is discriminatory.
Send us a question by tweet at C-SPAN, #landmarkcases. Your comment for that caller?
The Yick case took on a different meaning in the 20th century. If you look at Yick in 1886, and then only a couple years later you get to Plessy v. Ferguson, which upheld the separate but equal doctrine, you say, how can the court do both, right? How can you say, if you have an evil eye and an uneven hand, in the same breath as separate but equal, right? That's why a lot of scholars, Professor Jack Chin is one of them, suggest that Yick wasn't really a race case, that this had nothing to do with the the defendants being Chinese, that the fact that you had an arbitrary violation of a property interest, right, that could have played a huge role in this case. And if you look at it that way, the chronology makes sense. But you're absolutely right. Today, and starting in the 1960s, Yick has taken on a very different meaning, that when you have a facially neutral law that has an improper motivation, the courts can then still set it aside because of that animus behind it.
A little bit more on the operation of the court. Chief Justice Morrison Waite reached a unanimous decision in this case. Was that something he pushed for in almost all the cases that he heard?
I haven't done a thorough study of the Waite court, how unanimous their decisions were. But back then, there wasn't nearly as much dissenting as there was today. They were very busy. Today, the Supreme Court hears maybe 80, 70 cases a year. They're not very hardworking. Back then, they'd hear hundreds of cases a year. And it was tough writing a lot of dissents. In fact, you'd often have a justice saying, I dissent with no written opinion. So I think this was par for the course. But what's important here is that there was no vigorous disagreement. In other cases, like Wang Kim-ark and Fu Yangting, in these other cases, there were dissents, and they were vocal about them. But here, everyone was on the same page.
So what did the arguments on the side of the city of San Francisco, what were they all about?
Well, the city tried to argue that these Chinese laundries were unsafe. There were efforts to tie it to the opium industry, which was fairly prevalent back then. These were not credible arguments because the legislation at issue didn't actually determine if the laundromats were safe. That is, all the white laundry owners were having the exact same wooden structures as the Chinese laundry owners. And there wasn't any meaningful attempt to say why these were safe and why these were unsafe. This was what we call in the law a pretext, right? This was class legislation designed to protect a favored group and not a law actually premised on health and safety concerns.
It's in our notes, we said the city submitted photographs of the laundries. Photography was really pretty nascent back then. Can you tell us anything about that?
Right. It was actually fairly rare to have a photograph attached to a brief, but they were trying to show the judges that this was a problem. In fact, Justice Field was one of the members of the court. He had previously been on the California Supreme Court, so he probably had firsthand experience, and he didn't blanch at all at this. I think he understood that this was not this was a good legal argument, but it was not the true reason why these permits were being denied.
May I Twitter comment from EPWV Law, EP West Virginia Law, were other definable immigrant groups as likely to resort to the courts as were the Chinese? If not, was there a cultural tradition in their native country that made the Chinese immigrants more prone to seek redress in the courts?
I don't think the Chinese recourse to the courts has anything to do with their cultural background. It was a tactic they adopted because, as I said before, they did not have access to the vote. And they studied the law and they knew that they were being discriminated against, and they sought justice through the courts. There are other cases where immigrant groups went to the courts for justice. I'm thinking of Meyer v. Nebraska, which is a case of German language schools. So that's one case I can think of offhand. Can you think of others, Josh?
Well, the leading example, which May mentioned earlier, was the NAACP Legal Defense Fund, which grew up in the 1930s, 40s, and really the 50s to try to chip away at the separate but equal doctrine. One of the reasons why these various immigrant groups had to turn to the courts was even with the franchise, right? Even with the franchise, they still lacked the political power. And the courts at the time were viewed as reinforcing the representation of these politically powerless racial and ethnic minorities. This was an important channel by which they could seek redress where the democratic process was not helping them.
Our next question comes by phone. It's from John in West Palm Beach, Florida. Hello, John.
Yes, hello. I haven't watched this series much because I had to turn it off when you first started. It seems like you always have these very liberal cases with liberal commentators. Miss May, am I saying your name correctly?
It's Nye.
Professor from Columbia? Mai?
Nye, yes.
May Nye.
Okay, because I thought that in Chinese, the first name is last and the last name is first. Am I mistaken?
In China, but I'm an American, so my last name is Nye.
And John, do you have a question for us?
Well, I had a comment and then a question. I'll be brief. You made a comment earlier about how the white men wanted to drink and they weren't following orders as well as the Chinese. That's kind of a bigoted statement, considering that I'm of Irish descent, and a lot of Irishmen were heading west when they were building the railroad. Anyway, my question is this. If the Chinese were here illegally, how in the world could they be opening up businesses? Now, I know this is the 1880s, and it's not like today, but I don't hear anyone mentioning that. I mean, was that argued in the Supreme Court?
Okay, so to your first comment, that's not my opinion. That was what was said by the railroad companies, why they had trouble holding white labor. So that wasn't my opinion. That was the opinion of the railroad companies. And they were not really targeting Irish as an ethnic group. They were targeting former gold miners who had more of, shall we say, an adventurous spirit rather than, wanting to work hours on a clock, for the railroad. As to your second question, well, the Chinese exclusion law is not passed till 1882. So before that time, there were no restrictions on Chinese entry, so they were not illegal. They were not undocumented. They only needed to pass through an interrogation and receive a document after the exclusion law was passed. And they were mightily interrogated. They sometimes had to sit for days or weeks before immigration officials who asked them questions to see if they were legitimate or not. You could come in if you were a merchant, if you had a certificate issued in China that said you were a merchant. The first exclusion law was aimed at laborers. So if you were a laundry owner, and if you were here before 1882, you were not illegal. And if you came after 1882, you qualified to be a merchant. So these people were not here without authorization.
And would you explain once again about they could not apply for citizenship? They were restricted from that?
That's right. The Exclusion Act of 1882 suspended immigration of Chinese laborers for 10 years, and it excluded all Chinese from naturalization.
This is a variation of that question from Matt Smith on Twitter. How were non-citizens treated under U.S. law prior to Yick Wo?
Well, the most obvious example was the Dred Scott decision, which I think you covered on your program. Chief Justice Roger Taney held that people of African descent, whether free or enslaved, could never be citizens of the United States and lack the privileges and immunities, the rights that citizens are entitled to. But this raises a paradox. Who was a citizen of the United States before the 14th Amendment? The Constitution didn't specify who was a citizen. It was very much an open question. Section 1 of the 14th Amendment sought to reverse that and said all persons born or naturalized in the United States or subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. So if you had a person of Chinese descent had a child in the United States, that child became a U.S. citizen. But the parent could not, because the parent had to appeal to Congress for naturalization. And that's why the Exclusionary Acts excluded all foreign subjects from ever becoming U.S. citizens.
Next is a call from Brandon, watching us in South Bend, Indiana. Hi, Brandon.
Hi there. I'm actually a first-time watcher, first-time caller.
Great, glad to have you. What's your question? Brandon, are you there?
Yes, I'm sorry. Looking back at a history in a case such as this, involving Chinese immigrants, which they're still Chinese immigrants, there are going to be South Korean and North Korean immigrants, and we're going to have immigrants in this country. That's what it was built on. How do we apply these lessons that we learned from this case?
Thank you very much. That's something we do want to talk about in this program. How do we apply the lessons of this case to our society today?
I think it's really important that Americans understand that the Constitution, the protections of the Constitution apply to all persons who are living in the United States, regardless of their citizenship status. And I might say that that's the same thing with the Bill of Rights, the first 10 amendments. They speak of persons also, not just citizens. The right of free speech, the First Amendment, that applies to all persons. So I think we have a tradition in this country that goes back to the writing of the Constitution, including the Reconstruction Amendments, that recognizes that there's a large population in the U.S. that are not all citizens, not just the former slaves or African Americans, but also people from immigrant backgrounds.
Well, speaking to the specifics of this case, Mari Lane on Twitter asked about a certain aspect of history we may not have touched on. They write, there was a treaty with China that guaranteed privileges and immunities for Chinese subjects in the U.S. The Burlingame Treaty, 1868, that is a part of our story we should touch on. What should we know about it?
That's a very important part of the story, because in fact the plaintiffs in Yick Wo, when they made their argument before the court, many of their arguments actually concerned the treaty, that under treaty rights, Chinese had the right to pursue a business and an occupation in the United States. The Burlingame Treaty was signed in 1868. Anson Burlingame is a really interesting person. He was a free soiler from Massachusetts who was sent over to China in 1861. He was appointed by Lincoln to be the American representative to China. And when he was there, he was kind of appalled at the way Britain and other European powers treated the Chinese. And he was not a fan of gunboat diplomacy and what he called taking him by the throat. And he wanted to have a more friendly relationship with China. And so he lobbied other ambassadors in Peking, and he was made friends with the Chinese ministers. And in 1867, China appointed him to be their representatives to negotiate better treaties with Western countries. And Burlingame led a group of diplomats, and it also included a British diplomat, a French diplomat, and several Chinese ministers to the United States, and then they went on to Europe. So the Burlingame Treaty that was signed, it was sometimes called the Burlingame-Seward Treaty because it was negotiated with Seward from Lincoln's cabinet. The Burlingame Treaty was called the Treaty of Friendship and Amity, Friendship and Trade, and it had a provision in it that there would be free migration between the two countries. Nationals of each country would enjoy entry and privileges and equal protections in each country. It did not include the right to naturalize, but it did include the right to immigrate and the right to pursue an occupation or a trade, and to have the same protection as other people in the country.
So it seems like an important thing to mention in the arguments because of this treaty, the Chinese actually had special status that other immigrants might not. So how did it figure in the arguments?
Well, this treaty was one of the first treaties. There was a follow-up in 1880. Between 1868, when the first treaty was signed, and 1880, when the second treaty was signed, sentiments in the United States turned against Chinese Americans. And the 1880 treaty more or less allowed the government to put restrictions on the on the immigration of Chinese aliens. It also let them do some other things, one of which was it still protected the privileges and immunities of Chinese immigrants. And in fact, in the Yick decision, the Supreme Court cited this treaty of 1880 saying that even though he's here, he still is protected by virtue of this treaty. So the international aspect of this case actually figured prominently in the Supreme Court's decision.
Well, we heard the arguments on both sides for this case, and the opinion was assigned to Justice Stanley Matthews. Can you tell us anything about him?
Not a particularly well-known justice. No, in fact,
I can tell you a few copy points, and let me do that, and then you can add to it. Former Republican senator from Ohio, nominated by Hayes in 1881 and renominated by President Garfield in March of 1881, and confirmed by a 24-23 vote in the Senate, the narrowest ever for a justice. And it says on my notes that Yick was his biggest contribution to the court.
Yeah, I can't think of much else Justice Matthews did, although this opinion, which is significant in that it recognized a few major points. It recognized that the Due Process Clause applies to non-citizens, that the Equal Protection Clause applies to non-citizens. It even made reference to the famous Civil Rights Act of 1866, which said that people cannot be denied access to certain rights based on their skin color. So this opinion looped together a lot of major themes of the time.
Here's just a little bit of Justice Matthews' decision. It was a unanimous decision. He wrote it on behalf of the entire court, and here's some of what he wrote. No reason for it is shown, and the conclusion cannot be resisted that no reason for it exists except hostility to the race and nationality to which the petitioners belong, and which in the eye of the law is not justified. The discrimination is therefore illegal, and the public administration which enforces it is a denial of the equal protection of the laws and a violation of the 14th Amendment of the Constitution. More of that is discriminatory enforcement. Though the law itself be fair on its face and impartial in its appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution. What was the country's reaction to this decision? Do you know? Was it a big deal at the time?
I'm not sure that it was. Was it a big deal? I don't think people really remarked on it that much. I mean, the Chinese were happy, and I know Justice Field was happy because he had long pursued an agenda of economic rights and restraining government's interference in people's economic rights. But I don't think it got a lot of attention.
We found newspaper editorials in California that weren't so happy about it, which probably would not be surprising in the context of the papers and the Times.
Well, right. Well, California had long been nursing a grudge against the Chinese, and they had many, many laws against Chinese and discriminating against them. And, you know, it's a time when Chinese exclusion had been recently passed, and there's still a lot of agitation about getting rid of the Chinese. And the Chinese exclusion laws will be upheld by the Supreme Court, but that's not until 1889. So there's still a fair amount of uncertainty, I think, going on.
And we'll talk more about that in our next segment. But before we leave this part of it, the Waite Court overall, and you did touch on this, when we read those provisions of the decision, it's not consistent with other things coming out of the court at that time. Can you help us understand the court's mentality, psychology, thinking about these kinds of cases?
So this case was decided at the very beginning of what's often called the progressive era. Before this era, states usually had a laissez-faire approach to economics. They would let businesses do what they wish. But during this time, you had this progressive movement to regulate health, safety, welfare legislation. And the biggest opposition to this era were the courts, both state courts and federal courts, which in the 1890s and early 1900s, courts began to find various pieces of economic legislation unconstitutional that deprived people of their property or liberty interests without due process of law. This became known as substantive due process many decades later. Yick Wo, if you read it this way, fits well within that chronology in that you had a business owner who was being arbitrarily denied the right to continue a business that he had run for 2 decades. If you try to read it as a racial equality case, it sticks out like a sore thumb. Because only a few years later, you had Plessy, you had and a lot of other cases that looked away at blatant racial discrimination. Right? If the court's striking down a law based on an evil eye, how can they uphold something which is actually legitimately separate? So I think the economic liberty approach helps to fit this case in with a broader era, although it was a fairly early on opinion in this movement.
Welcome to our conversation about Yick Wo v. Hopkins, a case that dealt with the 14th Amendment's application to non-citizens. Next up is Sonia in Philadelphia. Hi, Sonia, you're on.
Hi, thanks for taking my call. I was just wondering, I guess you already mentioned that at the time when the decision was handed down, there wasn't really a lot of reaction from, people outside of the Chinese community. But I'm wondering, down the line, since San Francisco at the time and California was becoming so multicultural, if it helped that it was there at all, because if there hadn't been a strong Chinese community and a strong aid society, they might not have been able to have the resources to get this case to court. And at the time when a lot of new states were still needing to join the U.S., did it really kind of snowball and the effects became clear that aliens would have more rights in the 20th century, or would this have kind of gone unnoticed if it had happened somewhere else that wasn't as multicultural?
Thanks very much. There's a portion of that question for each of you. So let's start with Mei Nai.
It's a little hard to think about California as being multicultural in the late 19th century. It's overwhelmingly white. Asians or Chinese at this point, there aren't really that many other Asians yet, make up about 10% of the population, and the black population is fairly small. Unfortunately, most Native Americans have already been wiped out. So I don't know if we could really say it's a multicultural population. And the Chinese are almost uniformly despised by the white population. They don't have many allies in San Francisco. Sad to say.
Alas, this case was a bit of a blip. In the years and decades following Yick Wo, the Supreme Court upheld a number of exclusionary policies aimed directly at Chinese immigrants. Indeed, the original 1882 Act, which prohibited Chinese immigration for 10 years, was renewed another 10 years and then made ultimately permanent. So until 1965, with the Immigration and Nationality Act, you had basically a blanket ban on Chinese immigrants. So this case is very much an outlier, perhaps a celebrated outlier, but it didn't do much good until almost half a century later.
Well, you've just given a synopsis of things we're going to delve a little bit more into in our last half hour. We have about 35 minutes left to go in our discussion of Yick v. Hopkins. Coddy Man on Facebook says, with so many preaching about laws and rights, history is the easy way to show how far we have come. There had to be a law to protect non-citizens from citizens. Think about that. Most laws are created to build a society where one man is not allowed to wrong another man without repercussions. It's called being civil. Next call is from Bill in New York City. Hi, Bill. You're on. Welcome.
Hi. Yes, thank you so much for doing this. My question is, does this extend to United States territories like Guam, and when did that happen? And also, does it extend to, United States consulates, people working there who are from a foreign country working under, in consulates, and also prisoners at Guantanamo? I'm sure there are different rules that govern those, but does this extend to United States territories or wherever Americans are in control?
So it's actually a very complicated question.
Yes.
Take each piece in turn. The short answer is the Constitution does not apply in U.S. territories abroad. You mentioned Guam, American Samoa. There were a series of decisions called the Insular cases, and these cases held that people born abroad are not citizens by birth. And to this day, if you are born in Guam, you are not a natural-born citizen. You're a citizen by statute, right? You get citizenship at birth, but you're not a citizen by virtue of the 14th Amendment. As far as U.S. citizens living abroad, anywhere a U.S. citizen goes, the U.S. government has to protect them. So if you're a U.S. citizen in Japan, for example, and you commit a crime, you're entitled to a jury trial. And there's a very famous case about that. The final part, does the Constitution apply at Guantanamo Bay? This is a Boumediene decision. It was a 2008 case where the Supreme Court held that the writ of habeas corpus actually runs to Guantanamo because it's part of the territorial sovereignty of the United States. That's a dubious holding from Justice Kennedy, who spoke a few minutes earlier. He's not one to criticize mixed metaphors. But Justice Kennedy actually cited Yick for the proposition that non-citizens do get rights, even though they're outside the boundaries of the United States.
Any more for that question?
Well, when the United States acquired the territories it did after the Spanish-American War, Puerto Rico, the Philippines being the two major ones, there was a question posed by these insular cases, as Josh referenced, which were actually mostly customs cases, right? Did you have to pay duty on goods imported from Puerto Rico into the United States? And the way the question was framed in the popular press at the time was, does the Constitution follow the flag? And what the Supreme Court said was, well, maybe. We get to decide when it does and when it doesn't. So what parts of the Constitution applied abroad to the territories was actually quite arbitrary. Like in the Philippines, for example, people did not have the right to a jury trial. And they were not citizens. They were not even citizens by statute like they would be in Puerto Rico. They invented a new category called the national, who is neither an alien nor a citizen.
Joe is in Saline, Michigan. Hi, welcome.
Hello. Was the Chinese Exclusion Act was ever tested in the courts, and what happened? What was the result?
Yes and yes. So the question was, were the Chinese Exclusion Acts tested in the court? And yes, they were upheld. There were a number of decisions, one called Fang Yu Ting in 1893. And this case considered whether a Chinese person needed to obtain a certificate of residency to maintain his residency in the United States. And the courts upheld this. Another case called Che Chan Ping also dealt with exclusion. One after the other, the Supreme Court upheld these exclusionary policies. Indeed, Yick is the outlier. It was the only case where the Chinese person won. In all the other cases involving immigration in China, there were victories for the United States government.
Well, let's take a call, and then I want to come back and spend more time with that. Chuck in Alexandria, Louisiana. Hi, welcome.
Thank you. I'd like to say whoever came up with the idea for the show, they need a pay raise. And my question is, how does rulings from the 1800s affect rulings today? Are they used a lot, or have there been enough rulings in the 1900s to where they're not the rulings in the 1800s aren't really studied much? And I'm assuming this is what law clerks do, and I'll wait for your answer.
We're going to learn that there have been about 125 citations.
Yeah.
Just spend a moment on that because we will get to that.
And I was a former law clerk, so I guess I'm suited to answer this question. And yes, you do deserve a pay raise. You're doing a wonderful job tonight. The Yick case has been cited more than 150 times, generally for this idea that even if a statute is neutral on its face, that courts are able to look behind the statute to find an improper motivation. So I'll give you another prominent example. In the case of Lawrence v. Texas, which considered Texas's ban on sodomy, Justice O'Connor wrote a concurring opinion where she said, whether a sodomy law that is neutral both in terms of its effects and application violates the Constitution, that is, whether or not the sodomy law applies to gays and heterosexuals alike, courts can still determine if it is unconstitutional. So this is a case that's very often cited, although in my opinion cited for a much broader proposition than it was decided in 1886.
Well, you said this was the only case that the Chinese won.
Not the only one.
Not the first big one that they won, I guess we'll put it that way. Thank you. So did life change for the Chinese immigrants in San Francisco after this?
No, it got worse, actually, notwithstanding the decision in Yick, because with the exclusion laws being passed in 1882, it didn't end there. There was actually an uptick of violence against Chinese because the racists and the nativists wanted the Chinese thrown out of the country. So there was the worst violence against Chinese in the 19th century actually happened in the 1880s. There were massacres. The most famous was in Rock Springs, Wyoming in 1885, where nearly 30 Chinese were killed. People who worked in a coal mine, 75 houses were burned down. The mob mutilated bodies and tortured them. It was just absolutely horrific. But all over the West Coast, there were lynchings. There were mobs that drove people out of town. You know, sunset resolutions, get out of town by sunset. There were burnings in Chinatowns, people attacked everywhere. So things got a lot worse before they got better.
And did the law help to protect them at all? Were any of these people prosecuted for these acts that they committed against the Chinese?
Occasionally there would be arrests, but in general they were not prosecuted. In the Rock Springs case that I just mentioned, there were whites who were arrested. Well, first they had a very hard time arresting anybody because nobody would be a witness to say, you know, who were the suspects. But nobody was ever convicted in that case.
Specifically, do you know what happened to the Chinese laundries, since they were the heart of this? Were they able to continue their business?
They did continue. They did continue. And Chinese laundries sprung up all over the country. New York City had a lot of Chinese laundries in the early 20th century.
So, Josh, as you told us that from a legal perspective, more laws kept piling up that would try to insulate the white majority public from the effects of Chinese immigration. And you made reference to this case, but the Geary Act was the one that was examined in the Feng Yu Ting case in 1893. Here's a little bit of what the Geary Act did in 1892. Expanded restrictions on Chinese immigrants, required them to carry resident permits. Chinese immigrants were not allowed to be witnesses in legal trials, and also they could not receive bail if they were arrested. So were the Chinese really the only ones that had to carry identity papers in this country?
So our immigration laws, what we know today, began with Chinese Americans. There weren't many immigration laws on the books before these exclusionary acts. And in the Feng Yu Ting case in 1893, the court upheld the validity of this provision. And they said that the Equal Protection Clause doesn't prevent a person from being deported, right, so long as they don't have their paperwork in order. So even if the Constitution protected the Yick laundromats' right to stay open, it did not protect their right to be deported if they didn't comply with these laws requiring these certifications.
Can I add to that?
Please.
I think that the two immigration cases Fang Yuting, and the one that preceded it, Che Chanping in 1889. Those are really landmark cases that changed the course not only for Chinese immigrants, but for all immigrants, and they apply today. And in these cases, the court said that immigration is a matter of national security. Before this time, immigration was understood to be under the Commerce Clause. To justify Chinese exclusion and to justify the denial of equal protection, they said immigration was a matter of national security. Therefore, it's outside the Constitution. It's in the same basket of matters that Congress regulates, like declaring war, making treaties, having diplomatic relations with foreign countries. So in matters of entry and removal, aliens have no rights under the Constitution. None. And this is what our current president has used, the so-called plenary power or executive power over immigration, to justify the executive orders that were issued when he took office. So this idea that immigration is a matter of national security, and therefore that aliens do not have rights in matters of entry and removal, that comes from the Chinese exclusion cases, but it has undergirded our entire history of immigration law since that time.
And it all began with the period of time that we're talking about right now. Martin in Starksville, Mississippi, you were on. Welcome.
My name is Martin Jew. I'm from Starkville, Mississippi, and I am an American Chinese born and raised in the Mississippi Delta. My question is, how does the case in 1886 affect the American-born Chinese in Mississippi? And let me mention one other thing, that my great-grandfather helped build the Transcontinental Railroad back in the 1860s.
And how did your family get from the west coast of the United States down to Mississippi, Martin?
Well, they didn't come from the West Coast. They came directly, as I understand it, from China to Mississippi because cotton in the 1940s and 1950s was king back then, and there were jobs here then, but even before then, they came after the railroad and the gold rush was built.
Thank you very much for your call.
Wow, that's fascinating. Pleased to meet you, sir. The important case for Chinese born in America was not really Yick Wo. It was a case that came a few years later in 1898 called Wong Kim Ark. And in that case, the court affirmed the meaning of the first clause of the 14th Amendment, that all persons born or naturalized in the United States are subject to the jurisdiction thereof are citizens of the United States. And so that case affirmed birthright citizenship for Chinese Americans, right, born to Chinese immigrants in the United States. And in that case, the court actually didn't have a big love for Chinese people. It said the wording of the Constitution is pretty clear-cut, and if we deny it to Chinese, we'll jeopardize the citizenship of all the children of the Europeans.
And one point to add to that, Wong Kim Ark was an important case because it tested the meaning of subject to the jurisdiction thereof. If you notice in the Yick Wo decision, they say that Li Yick was a subject of the Emperor of China. There was a very strong belief that people of Chinese descent were always loyal to the Emperor of China and were always subject to his jurisdiction. Indeed, decades later in the Korematsu case, which involved Japanese detention, the same pathology continued, that these people were so loyal to the Emperor of Japan, even if they'd been in the United States for decades. So at least Wong Kim Ark was an important case that said it doesn't matter if they're born here, they're subject to our jurisdiction, and they're citizens at birth.
One of the effects of the immigration laws targeting the Chinese citizens, Chinese entry rather, was how they were processed for their entry into the United States. We're going to learn about that next. You're going to be visiting with our cameras Angel Island. If you've been to San Francisco, you've heard about Alcatraz. Well, Angel Island is just north of that in San Francisco Bay, and we visited that and talked with Palma Yu of the Chinese Historical Society to tell us more about what it was like for Chinese immigrants being processed there.
Angel Island becomes a checkpoint for immigrants. What the U.S. does is they build barracks to house immigrants. And this is a replica of those barracks. They made themselves at home in the barracks on Angel Island. They had to, they didn't have a choice. They brought their clothes, their best clothes, because they wanted to present themselves well and appear like they were worthy of being here in the U.S. And they brought whatever it is they needed to occupy themselves during that time. They had an inspection office where immigrants were interviewed because somebody here in the U.S., a Chinese that was already here, had to sponsor an immigrant. In order for the U.S. to verify that you were in fact a real relative, they would first ask all the questions to the sponsor, and then the sponsoree had to answer those questions. What the inspectors asked about was where they lived, how they lived their lives in China, where the water source was, which direction the house faced, who lived in the house. If he got all the answers right, he was allowed entry onto U.S. soil. If he didn't, he was deported. You had to go through a health inspection. What the inspectors were looking for was spreadable diseases that would be a threat to the society here. And if you were found to have some disease, I believe you were not allowed entry. They didn't get their interview right when they arrived. They had to wait their turn, and sometimes that waiting period could be months. Sometimes it was years, 2 years. They were not helpless, but they were trapped for a while on Angel Island.
Did the Chinese exclusion laws help to solidify the creation of Chinatowns in major cities all around the United States? And did those become safe harbors for Chinese?
Chinatowns are the byproduct of two things. On the one hand, they're the product of segregation, because Chinese are not allowed to live anywhere else, either by law or by custom. But at the same time, they become ethnic communities, and they do promote a closeness of people, solidarity. So I think both of those things are the case, yes.
And while we're talking about them, what's happening to them today around the United States?
Well, you know, Chinatowns are often in close to downtown areas, near central business districts, so the real estate's really valuable. So there's a lot of pressure on Chinese communities. Buildings are bought by others. They want them evicted. That's happening in Los Angeles right now. There are people fighting evictions in LA Chinatown. New York Chinatown is right up against Wall Street. So there's a lot of gentrification that goes on, you know, young professionals moving in. So there's a lot of pressure on these communities, yes.
And that's how I'd like to spend our last 15 or so minutes, is talking about the 20th century history of all of this. Let me take a couple of quick calls, and then we're going to learn what happened legislatively on Chinese immigration laws in the 20th century. Clifford, Modesto, California. Hi, you're on.
Hello. I wondered if the Yick case and the 14th Amendment would have any effect on the Dreamers today.
Okay. Thank you. I'm going to reserve that for just a little bit. That's a good question. Dennis, Clive, Iowa. Go ahead, please.
Thank you. Thank you. I wanted to follow up on a suggestion I gleaned from the gentleman earlier when he seemed to indicate that Yick Wo can be understood better in relation to economic freedom or liberty as opposed to racial discrimination. Are you suggesting that Yick Wo was a harbinger or precursor of Lochner? In other words, just skip over Plessy and go straight to Lochner to figure this thing out.
Thank you.
You're asking about all my favorite cases. So for those who don't know at home, Lochner versus the people of New York considered a baker in Utica, New York. And New York passed law limiting how many hours a week a baker could work. And this was actually a criminal statute. There was a test case there as well. And a baker deliberately worked more than 80 hours a week and was arrested. In a very famous 5-4 decision of the Supreme Court, the court struck down the New York law, finding that it violated the liberty of contract. This was a liberty interest protected by the Constitution. The Lochner era, as it's often called pejoratively, didn't really begin until the late 1890s and the early 1900s. But I think if you read the decision in Yick Wo, and if you read the Circuit Court decision, or the Court of Appeals decision in a related case, it references class legislation that's passed with a pretext. So I think there's a very strong economic liberty component to this decision that's often, I think, not given its full due. Again, if you try to read it as a racial equality decision, it's tough to fit in with Plessy and some cases that came in the subsequent years.
You've made the point, both of you, that anti-Chinese laws continued and anti-Chinese discrimination continued for about 60 more years in the United States. In 1943, Congress passed the Magnuson Act, which allowed limited Chinese immigration, but still only 105 visas, 105 to Chinese immigrants. What progress did the Magnuson Act make for Chinese immigrants?
Well, the Magnuson Act, I think, has to be understood as a World War II era act. China was a war ally of the United States. Japan was making a lot of hay over the fact that the Chinese were excluded from the United States, and they said, what kind of ally is that excludes your people? So Chinese exclusion was repealed as a war measure, and to kind of squelch that negative propaganda coming out of Japan. But it really wasn't to help the Chinese people to immigrate, because they imposed a quota of 105 a year. And that quota applied not just to people in China, but to all Chinese people around the world. So if you were a Chinese in Hong Kong, a British territory, or a Chinese person in Cuba, or wherever, you were subject to that 105 quota. But it was important because it repealed the ban on naturalization. So Chinese who were in this country as lawful residents could now naturalize. And it also opened up the immigration of women, wives of Chinese who had not been able to come over to this country. So it was important in that respect.
20 years later, Congress passed the Immigration and Nationality Act. Johnson signed it into law. What did it do?
This was a significant law, and perhaps the most important aspect of this law was it eliminated the quota system, where people from certain countries could apply based on whether the country was desirable or not. This law said that now the issuance of immigrant visas cannot be discriminated on the basis of nationality. And to bring this to the present day, that's a core component in the challenge to President Trump's travel bans, of whether this amounts to nationality-based discrimination in violation of the 1965 Immigration and Nationality Act.
In 2012, Congress issued a formal apology to Chinese Americans for their struggles in immigrating to the United States during the 19th and early 20th century. U.S. Representative Judy Chu of Chinese descent, a California Democrat, sponsored the resolution. Here is her on the floor of the House talking about it.
The Chinese, like my grandfather, did not have the legal right to become naturalized citizens. He had been here legally since 1904, but unlike non-Chinese immigrants, he was forced to register and carry a certificate of residence at all times for almost 40 years, or else be deported. He could only be saved if a white person vouched for him. These laws are why we ask for this expression of regret. Last October, the U.S. Senate did its part to write history by passing their own resolution of regret for these hateful laws. It did so unanimously with bipartisan support. And today, the House should also issue its expression of regret. It is for my grandfather and for all Chinese Americans who were told for 6 decades by the U.S. government that the land of the free wasn't open to them that we must pass this resolution. We must finally and formally acknowledge these ugly laws that were incompatible with America's founding principles. We must express the sincere regret that Chinese Americans deserve. By doing so, we will acknowledge that discrimination has no place in our society, and we will reaffirm our strong commitment to preserving the civil rights and constitutional protections for all people of every color, every race, and from every background.
And in fact, both houses of Congress did pass such resolutions. So we have just 10 minutes left, and we have learned that this case has important implications for immigration policy and also for commerce in the United States. We're going to focus on some of the immigration questions. For example, the caller that asked whether or not it has implications for the debate over the Dreamers, the DACA. Does it?
Well, the Dreamers are people who came to the United States as fairly young people. They either came here illegally or they came here with a proper visa and they overstayed. Either way, it works. The Dreamers don't have a constitutional right to citizenship because they were not born in the United States. What they do have is a right to petition Congress, and it's up to Congress to grant them naturalization. That's been an ongoing status. President Obama tried to sidestep Congress's inaction with a program called DACA, Deferred Action for Childhood Arrivals. That is now currently being held up in the courts as President Trump tried to rescind it, and the courts told him that you can't do this. But eventually, whatever the courts resolve there doesn't grant the question of whether the Dreamers will get permanent citizenship.
Related to that, a viewer on Twitter asked, could our guests go into more detail regarding the legal treatment of people who are born or living in U.S. possessions, such as Guam and the Marshall Islands?
Well, perhaps the most famous such person is John McCain. He was born in the Panama Canal Zone, and when he ran for president in 2008, there was a serious question of whether he was a natural-born citizen. There were some people who says he was, some people he wasn't. Fast forward to 2016, we have Ted Cruz, a senator from Texas. He was born in Canada to American parents. And the question was he a natural-born citizen? And some people said he was, some people said he wasn't. But if you're born in Guam or American Samoa, to this day, you are not a natural-born citizen because the cases that May mentioned, the insular cases, suggested that the full flag, the full Constitution does not extend to these territories. You're a citizen by statute. That is, Congress passed a statute. But where Congress repealed that statute, you will be less than a citizen, and you would not be entitled to all the rights, privileges, and immunities that citizens do receive.
Our last, go ahead.
Actually, McCain and Cruz are also citizens by statute. They're derivative citizens. They're not 14th Amendment citizens. They derive their citizenship from the citizenship of a parent.
They argue they are natural born.
They're natural born, but they're not birthright citizens.
They say they are.
I don't think they are.
This is an interesting whole other program I think we could have. Our last caller for this program is Dennis, Whitmore, Iowa. Hi, Dennis.
Hello.
Yes, sir, you're on the air. Welcome.
My question would be, same set of facts today. Would they say that this is a human rights violation? And, like, say, if you went to the international courts, would say it's a human rights violation, and if the U.S. Supreme Court would recognize that? Thanks.
I had difficulty hearing the question.
Would the same situation today be seen as a human rights violation?
Well, the phrase human rights has a very distinct meaning in terms of international law. Our courts do not apply international law. They apply domestic law. I can't speak to what The Hague would say about our immigration policy, but at least under American policy, May is quite right that the plenary power doctrine that was established in these cases, that is, Congress has complete power of immigration, for the most part stands to this day. There are some who hope to chip away at that doctrine, but it's still in the books, and that still forms a basis of how we can deny entry to people from various countries.
I want to get to, go ahead, May, sorry.
Well, a lot of people can make an argument that their human rights are being violated. The problem is one of jurisdiction and standing. The United States doesn't have to recognize anything an international court says to it. And in the case of immigration, it will not go by what any external court says. But can I add something about the Dreamers, which I think is important? Josh is absolutely right that they don't have a birthright citizenship because they're not born in the United States. But they are the generation that benefited from the Plyler decision. The Plyler decision of 1982 was a Supreme Court case that said undocumented children have the right to an education. Now they're talking about K-12 education. This was challenging a Texas case that was going to deny school children who were undocumented access to the Texas public schools. And the Supreme Court struck that down and said it violated the 14th Amendment, that you cannot punish children and consign them to a life of illiteracy and marginalization. So that's 1982. Fast forward, the Dreamers who come out in 2010, that's the Plyler generation. That's a generation who went to school, then hit a wall. Couldn't get a job, couldn't get a driver's license. Maybe some of them went to college, then they hit another wall. So we recognized this right of these young people to go to school, and I don't think it should just be snatched away from them.
I want to get to a wrap-up of this case, so Robert will be our last caller for the program. Go ahead, please.
Hello?
Yes, sir. Question?
I have a comment. This Supreme Court case is one of the rare Supreme Court cases to get mentioned in a Hollywood movie because in the Bridge of Spies, which is about the true story of a Soviet spy who was swapped later with a downed U-2 pilot, Francis Gary Powers. His lawyer, James Donovan, played by Tom Hanks, tells a federal judge that he says 1886, Yick versus Hopkins, and how in that, as you've mentioned, the due process of law, cannot be denied to a non-citizen, and so he feels that his client, under the Fourth, is being denied his due process rights, and then later on he argues before the Supreme Court in 1960, again, the same argument about Yick versus Hopkins for his client.
Thank you so much. Fun to get some contemporary movie treatments into these historic cases. Appreciate that call. Okay, we have just a few minutes. I'm going to look at both the legal and the historical legacy of this. You mentioned more than 150 citations in subsequent cases. You had a top 5. You've talked about, we're going to put those on screen, please. Regents of University of California v. Bakke, which is going to be our final case in this series. Shute versus Cole to defend affirmative action, immigration and integration rights. Shelby County versus Holder, that's Eric Holder, former Attorney General. Bermudian versus Bush, which was the Guantanamo Bay case, and Lawrence versus Texas. You've talked about most of those. Give us a little preview about how the citation with Bakke, which is our final case.
Right. So Bakke was a famous case from the 1970s that invalidated the University of California's affirmative action policy. And in that case, the court said that a quota system, right, setting aside a certain number of seats for racial minorities was unconstitutional. But the court cited Yick for the idea that the guarantees of equal protection are, quote, universal in their application to all persons without regard to differences of race. So here you have Yick being cited against the affirmative action policy. The idea that using race in a positive fashion was also unconstitutional. This is a very controversial idea. Today, Justice Harlan, in the Plessy case, said that our Constitution is colorblind. Not everyone today likes that quote because a lot of people want the Constitution to consider color for positive purposes such as affirmative action. So there's a distinct legacy here of when can you use race for in a positive fashion and when can you use race for a negative fashion. And that's still something that's vigorously contested today.
So we're going to have ourselves come full circle, May Nye. This is a 14th Amendment case, particularly emphasizing the provision that says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Put a historical summation for us. What is the importance of the Yick case to American society over time?
It means that we can't discriminate against immigrants. We can't withhold from them rights that we give citizens. I mean, the two main rights that citizens have that immigrants do not have are the right to be territorial present, meaning you can't be thrown out of the country, and the right to vote. And other than that, all people in this country have the same rights. And I think that's really important because we are a really diverse country. We have a large immigrant population. It's not as big as some people think. It's about 13% of our population. But I think it's really important that we have a society that treats everybody equally.
Historical importance of the case.
The key aspect of Yick is it teaches a lesson for the courts that even if a facially neutral law exists, that the law in its face doesn't mention race or religion, that courts are empowered to look behind the face of that statute to find an improper motivation. And that's something the court has done quite often in the last several decades.
Thank you, Josh Blackman. Thank you, May Nye, for helping us understand this 1886 case, Yick Wo. And special thanks to our friends at the National Constitution Center who helped us with the selection of the cases for this entire series. Thanks for being with us. We have 12 cases altogether, and we hope you'll be with us for more of this journey as we learn about significant Supreme Court cases and their impact on our society.
Next week on C-SPAN's Landmark Cases, we'll explore the 1896 case of Plessy versus Ferguson, where Homer Plessy, an African-American man, was arrested in New Orleans for taking a seat on a train car reserved for whites. The Supreme Court's 7-1 decision established the separate but equal doctrine that allowed segregation through most of the 20th century. This narrow interpretation of the 14th Amendment wasn't overturned until the Brown versus Board of Education decision desegregating schools. Watch Landmark Cases next Monday and join the conversation. Our hashtag is Landmark Cases, and follow us at C-SPAN. And there are lots of resources on our website for background on each case and where you can order the Landmark Cases companion book. Also, find a link to the National Constitution Center's Interactive Constitution. Go to cspan.org